Today, I'll introduce the concept of employment as a property interest and procedural due process. Traditionally, when we think of property, images of physical assets such as land, buildings, and personal belongings come to mind. However, in legal terms, property is a broad concept that includes intangible assets and certain rights, including intellectual property, contractual rights, and the right to one's employment under certain conditions. The concept of employment as a property interest is important because it forms the bedrock of procedural due process in the workplace. In employment law in the United States, employment can be considered a form of property under certain conditions. This is particularly true when an individual has a contractual right to employment or a legitimate claim to continued employment. For example, if someone has a contract that stipulates they can only be fired for just cause, then that person has a property interest in their employment. This is because the contract creates an expectation of continued employment, which is protected by law. When employment is considered a property right, the termination of that employment may trigger due process protections under the 14th Amendment of the U.S. Constitution. This means that before being deprived of this property right, that is losing their job, the individual is generally entitled to some form of procedural fairness, such as a hearing or an opportunity to respond to allegations. The concept of employment as a property interest is not a universal and can vary depending on state laws, the terms of employment, and other factors. For example, in at-will employment situations, which I introduced in the previous video, where either party can terminate the employment relationship at any time without cause, the employment is generally not considered a property right. In the United States, employment is generally considered at will unless there is a specific agreement or statute that provides otherwise. In an at-will employment relationship, either the employer or the employee can terminate the employment relationship at any time for any reason or no reason at all, as long as the reason is not illegal, such as discrimination based on race, gender, or other protected characteristics. However, employment can be considered a property right under certain conditions, such as employment contracts, collective bargaining agreements like those negotiated by unions, statutory protections, employer policies, and tenure. When those conditions apply, employment becomes a property interest when there is a legitimate expectation of continued employment. It means if you have a property interest in your employment, your employer must follow procedural due process before terminating your employment. For example, a university professor with tenure has a property interest in their job. This means that the university cannot arbitrarily dismiss the professor without following a fair and established process known as procedural due process. This process includes providing notice of the reasons for potential dismissal and an opportunity for the professor to respond, ensuring decisions are made justly and transparently. Likewise, a teacher or an educational administrators in a public K-12 school district who has a fixed-term contract or just cause contract with the school district has a defined property interest in their employment. This means their employment cannot be arbitrarily terminated before the end of the contract period, and any dismissal must be for just cause, which is clearly defined in the contract terms. For example, if an administrator is hired on a 3-year contract, the school district must generally adhere to the full term of the agreement, barring any misconduct or other serious issues defined in the contract. The presence of a just cause clause ensures that termination can only occur if there is a legitimate and substantiated reason, such as proven incompetence, misconduct, or financial necessity of the district. With the property interest in their employment, the administrator is entitled to procedural due process, which typically includes notice of the reasons for potential termination, an opportunity to respond or challenge those reasons, and a fair hearing process. This contractual arrangement not only provides job security for the administrator, but also ensures that any termination decisions are made with transparency and fairness. Let's look at a recent case that covers multiple aspects of procedural due process. In the case of Phyllis Edwards v. Dothan City Schools 2023, Edwards was formally appointed as the superintendent of the school district on January 16, 2018. Her employment term was set to begin in a little over a month later on February 26, 2018, and was slated to extend through June 30, 2023. The contract provided that Edwards could resign with or without cause as long as she gave at least 120 days notice in writing of her resignation to the board. Moreover, one clause in her contract provided a safeguard for termination. Termination was only possible for cause, specifying that any such action would not be effective until Edwards was presented with a written statement outlining the cause for termination and was given an opportunity for a hearing. Despite this contractual safeguard, Edwards found herself navigating challenging waters with the school board. 2 years later, on September 8, 2020, she sent an email to the school board indicating her intent to resign. Her letter states, "I intend to tender my resignation to the school board. Please let me know who I should deal with to iron out details." Do you see any potential problem with this resignation email? Here is a key factor. In Edwards' intent to resign email, she left out specified departure date. This makes it different from an official resignation. If Edwards had stated a specific departure date in her intent to resign email, it would have served as a more formal resignation notice to the school board. She could then follow the contract's procedures for resignation, which required at least 120 days written notice to the school board. Including a departure date would limit the board's ability to frame the email as an intent and vote to unilaterally terminate her contract on their terms. A mere 6 days after the intent to resign email was sent, on September 16, the school board acted swiftly and voted to terminate her contract. According to the board meeting minutes, the school board voted to accept Edwards' intent to resign. Edwards filed her lawsuit against the school board and the individual board members, claiming, among others, deprivation of due process and breach of contract. The key issue in this case is procedural due process and the circumstances under which a public employee can be terminated. Edwards asserted that she had a protected property interest in her employment because she could only be dismissed for cause. As a result, the school board's interpretation of her letter as a voluntary resignation was incorrect and amounted to deprivation of her due process rights. The 11th Circuit first acknowledged that Edwards has a property interest in her employment because her position was one that could only be terminated for cause. This property interest, therefore, requires the provision of due process before termination. To establish a property interest in employment, we generally need to demonstrate that there is a legally enforceable expectation of continued employment. The most straightforward evidence is a formal employment contract that specifies the terms of employment and the conditions under which termination can occur. In Edward's case, her employment contract stated that her termination was only possible for cause this specification creates a constitutionally protected property interest requiring due process protections. The court then looked at whether the school board's interpretation of her intent to resign email as a voluntary resignation was a random and unauthorized conduct or a deliberated one. If the board's actions are random and unauthorized, then an employee may not have the right to due process, such as a formal hearing, before being fired. The idea is that the state could not have predicted or controlled the unexpected behavior of its employees. In such cases, there is a belief that providing pre-deprivation due process would be impractical or even impossible. Essentially, the court needed to decide whether the school board acted on a whim or had thought it through before making their decisions to terminate Edwards. In this case, the court examined the evidence, including Edwards' employment contract and the minutes from the board meeting where her employment status was discussed. The court concluded that the actions of the board were not random and unauthorized, as there appeared to be a calculated interpretation of the Edwards letter. The board engaged in a systematic review of Edwards' letter and the employment contract, indicating a deliberated process rather than a random act. The minutes from the school board meeting showed that Edwards' employment status was a subject of discussion, further pointing away from act being random or unauthorized. Given Edwards' protected property interest in her employment, any actions influencing that status would likely be subject to scrutiny, making it improbable that the board acted in a random and unauthorized manner. There were no emergency situations mentioned that would necessitate bypassing pre-deprivation due process. The court inferred that the board's actions were calculated, not random and unauthorized, thereby obliging them to afford Edwards pre-deprivation due process. Given her protected property interest in her employment, the board should have offered Edwards an opportunity for a hearing before terminating her employment. If Edwards could only be terminated for cause, her intent to resign would not generally negate her right to pre-deprivation due process, such as a hearing. The purpose of due process is to ensure fair procedures prior to depriving someone of a protected property interest like employment. Therefore, even if her letter was interpreted as expressing an intent to resign, a hearing or similar procedure would typically be required to validate that interpretation before proceeding with termination. By failing to do so, the board violated due process. What can we learn from the Edwards case? Administrators should uphold due process principles when contemplating employment termination. If an employee holds a protected property interest in their job, defined by the stipulation that they can only be terminated for cause, a pre-deprivation due process, such as a hearing, is legally mandated. Ambiguities in written communications, like an intent to resign, should be clarified through formal procedures to mitigate the risk of due process violations. An email clearly stating departure date without ambiguity or the word intent could be construed as a formal notice of resignation. Removing the word intent could significantly change the meaning of the communication, shifting it from an expression of a possible future action to a clear statement of resignation. This would indicate that the employee is voluntarily ending their employment on the specified date. If the email is interpreted as a definitive resignation, the school board may argue that there is no need to terminate the contract because the employee has voluntarily resigned. In this case, the process of termination for cause, as well as the associated due process requirements, may not apply. And remember, being explicit and clear in all forms of communication, particularly in documents relating to employment status, can go a long way in mitigating legal risks. Here is another case. Before I present the case, I have 3 questions for you. First, does the director of student service who has a fixed-term contract have a property interest in her employment with the school district? Second, is a verbal offer from a school district superintendent sufficient to create a property interest in continued employment? Third, can the director have a property interest in continued employment without a signed employment agreement? Here is the case. In the summer of 2019, Quintella was hired as a director of student services by a school district's Board of Education in the state of Illinois. Her contract was for a 1-year term starting on July 1st, 2019, and not extending beyond June 30, 2020. This was a fixed-term contract. The director of student service had no guarantee of contract renewal. While her superintendent evaluated her performance in February 2020 and told the director that she would recommend to the board that the director's employment be renewed for the forthcoming school year due to the director's excellent performance. The director asked for a raise, but the superintendent indicated that her salary and all other terms of her contract would remain the same as in the prior year. The director agreed and had a mutual understanding with the superintendent that her employment, subject to the school board's approval, would be renewed on those terms. On March 17, 2020, the school board gathered to deliberate on retaining administrators and review their contracts. After identifying necessary amendments, they decided to postpone the vote. Then, on March 24th, during a closed session, the school board approved the employment agreement for the Director of Student Services from July 1st, 2020 to June 30, 2021. The board president wasted no time emailing the agreements to the superintendent. The next day, the superintendent emailed the Director of Student Services her contract with a March 31st deadline for her signature. Upon closer inspection, the director discovered that her vacation days had been reduced from 20 to 15, a change that applied to all administrators' contracts. The superintendent advised her to address this concern with the board president. Later that day, the director of student services fell ill with a presumptive case of COVID-19. Despite being advised to quarantine for 14 days and make multiple emergency room visits, she completed some work from home. However, she failed to sign and return her contract. When the superintendent reminded her on April 1st, the director of student services admitted she wanted her attorney to review the agreement. The superintendent cautioned the director about a precedent of releasing an administrator who missed the deadline. By April 2nd, the director of student services position was posted as vacant due to her unsigned contract. Ultimately, she never signed the contract or reapplied for her position, which was filled in June 2020. She completed her initial 1-year term and filed a lawsuit against the school district, the school board members, and the superintendent. The director argued that the school district deprived her of a procedural due process by rescinding her employment agreement and posting her position as vacant without proper notice or a chance to be heard. Did the school district deprive her of a procedural due process? To answer this question, we need to first look at whether the director had a property interest in employment that would entitle her to the procedural protections before her job can be terminated or her benefits can be changed. The director was initially hired for a 1-year term with a defined start date and end date. Her employment contract contained no provision for renewal, and she did not have a statutory or contractual right to continued employment or other job protections. In this case, the director had no property interest in her employment with the school district. Second, is a verbal offer from a school district superintendent sufficient to create a property interest in continued employment? In general, a verbal offer from a superintendent may be sufficient to create a property interest in continued employment if the offer includes definite terms and conditions of employment and the employee reasonably relies on that offer to their detriment, for example, by declining other job offers or making financial decisions based on the expectation of continued employment. The director argued that she had a mutual understanding with the superintendent that her employment would be renewed for the forthcoming school year. However, in that case, the relevant statute only implicitly allowed for oral agreements for terms of 1 year or less, and the school board had offered the director a written agreement. Therefore, a verbal offer from the superintendent was not sufficient to create a property interest in continued employment. The court held that the director did not have a property interest because she had not signed the employment agreement that was offered to her and therefore had no enforceable expectation of continued employment. Third, can an administrator have a property interest in continued employment without a signed employment agreement? In this case, the answer is no. The administrator argued that she had an oral agreement with the superintendent that she would be employment for another year on the same terms as the previous year, and that the school board's subsequent vote to approve her employment was a ratification of that agreement. However, the court disagreed with the administrator's argument because there was no written agreement, and the school board's vote tied to the terms set forth in a subsequent written contract. It's important to have clear and unambiguous documentation in employment agreements. The takeaway for administrators is clear. The property interest in continued employment is contingent upon signing a legally binding employment contract and agreeing to its terms. When it comes to accepting job offers, the court made it crystal clear that deadlines for acceptance are important and need not always be explicitly stated in the formal contract itself. In this case, the superintendent, in an email to the director, specified a date by which the contract needed to be signed to secure her continued employment. This date served as the deadline for her acceptance of the job offer and the associated contractual terms. As a direct consequence of this clear email communication, the deadline was deemed enforceable in the eyes of the law. When the director failed to meet this stipulated deadline, the school district acted within its rights to post her position as vacant and initiate the search for a replacement. The director received a verbal commitment from the superintendent regarding a position for the forthcoming academic year. This verbal promise, while encouraging, does not create a legally binding property interest in the position. Merely receiving a verbal promise or receiving a contract does not provide the individual with a concrete entitlement to the position. To transform this promise into a legally recognized employment right, the director must formally sign a written contract explicitly acknowledging and accepting the terms and conditions specified within it. The employment contract serves as a legal assurance stipulating the duration of employment, the agreed-upon salary and benefits package, and the specified conditions under which the employment arrangement may be terminated. This written agreement not only safeguards the rights and expectations of the employee, but also establishes a contractual framework that binds both parties to the agreed-upon terms. If you want to keep your job, you'd better promptly respond to employment offers and take proactive measures to secure your position. This principle holds true even in challenging circumstances such as facing a health-related issue or personal hardship. Regardless of the difficulties you may be experiencing, meeting your employment obligations remains essential. In situations where responding to an offer within the given timeframe poses a challenge, it's advisable to take proactive steps. For example, if you find yourself dealing with a pressing personal matter or illness, you can communicate with the employer and request an extension for the response deadline. A polite and well-documented request for additional time can demonstrate your commitment and professionalism while addressing your specific circumstances. Moreover, seeking a written extension, when possible, provides a clear record of agreed-upon timeline extension. This can help prevent any misunderstandings or disputes later on and maintains transparency between you and the employer. Failure to sign the employment agreement carries the potential risk of losing the job. This is exactly what happened to the director because she neither signed the agreement nor requested an extension of time, nor reapplied for her position. As a result, her position was posted as vacant and was filled 2 months later. Here is my question for you. Consider you receive a verbal offer from a position in a public education institution, contingent on the school board approval. Based on this offer, you make significant life change decisions, such as resigning from your current position. However, before the school board's official approval, the offer is unexpectedly retracted and the position is canceled. What legal recourse, if any, do you have? Consider the principles of employment as a property interest and procedural due process I introduced in this video. Please leave your comments below. Thanks for watching. I'll see you next time.